Hello, everyone. How's it going? This is immigration attorney Moumita. I hope everyone is having a lovely day. Happy Thanksgiving to those of you who have celebrated, and welcome to my live. I'm here to talk to you about immigration and to answer some of the questions that you may have on your mind. And as I do with every single live, I'm going to start out this conversation with a very important immigration topic. And today's topic is, if you have an illegal entry into the US, are there any ways of fixing your status without having to leave, especially if you are either married to a US citizen or have an adult US citizen child? So thank you so much for everyone who is joining me today. I'm going to talk about these very important questions. And before I go any further, my name is Moumita Rahman. I am an immigration lawyer. I have been an immigration lawyer in the US for the past 11 years. And it is my honor and my pleasure, and I love what I do, and I love to serve immigrants, and so does my team. And if you do need an appointment for a consultation, please call 212-248-7907 so that I can review your case and figure out what sort of immigration options that you may have and some solutions to your problems. All right, so let's go ahead and talk about this important topic today, which is, if you have an illegal entry, is there any way for you to fix your status inside the US without having to leave? This is such an important question because a lot of you have been here for 10, 20, 30 years, and you have an immediate US citizen relative, but you do not want to have to leave the US because it is very risky and you're worried about what may happen. And I'm here to tell you that there may be ways to fix your option. The only way to find out, of course, for sure, is to do an appointment. However, I'm going to go over the top few ways to fix your status in the US, especially if you are married to a US citizen or you have an adult US citizen child. The first step that I like to look at without having to leave the US is something called Vawa. Vawa is a self-petition. The form is the form I-360, and this form is very, very important. This is an application that not a lot of attorneys look at because the first instinct is to not talk about marriage problems. Nobody wants to talk about marriage problems, but they exist. And what I like to do is I like to see if you have any sort of issues with your spouse, whether they are a green card holder or whether they're a US citizen. If you have certain problems, for example, if your spouse is, you feel very stressed out by your spouse's reaction, you're afraid to get them upset, you're afraid to get them mad, maybe your spouse has even threatened to use the immigration process against you, right? For example, or maybe they have kicked you out of the house. Maybe your spouse has threatened to take your kids away when you're having a fight. These are things that hit differently when you are an undocumented immigrant. When you're an undocumented immigrant and you are going through these sort of marriage problems, they don't feel the same because at the end of the day, you may always be worried about getting deported. You may always be afraid of getting arrested. You may always be afraid of never being able to see your family or live with them again. And these are serious issues. And if you have ever felt any sort of this sort of stress, then they may be the sort of marriage problems that help you qualify for an application in the US. And guess what? If other attorneys have told you that you have to leave the US, you have to do a waiver, or you have even been told by others that you don't even qualify, you can't even leave the US because you may have something called a permanent bar, then VAWA may be a good option. And I would love to go over it with you in your case. Now, this is the number one case that I look at when people are married to a US citizen or to a green card holder who have been told they have to leave the US in order to do the green card process. Now, what happens if you don't have, you are not having any marriage problems, right? What happens, because this is something that people say to me, oh, everything's perfect. However, what I would say is think about it honestly. Think about it honestly if you have ever felt these sort of hesitations about doing the process with your spouse, or maybe you already started the waiver process. What happens if you have already started the waiver process and now you are no longer with your spouse, things are not going well, maybe you've even separated, maybe you have separated from your spouse, or you are going through a divorce. And I wonder if you did go through any of these feelings or problems, and if that's the case, then we may be able to start doing the I-360 process, even if you have already started the waiver process, okay? Only way to find out for sure is to definitely have me take a look at your case. Now, another thing that I want to look at is this. What if your spouse is in the military? What if you have an illegal entry, but your spouse is in the military? Can you qualify to fix your status in the US with this? And you may be able to fix this. And this is called military parole in place. Military parole in place is a really great option for persons who are married to a veteran or to somebody who is active in the military, or maybe even in the reserves, or their child is also in the military and an adult and able to sponsor them. You may not have to leave. However, please do keep in mind that if you have anything serious, such as the permanent bar as part of your immigration history, then military parole in place may not be a good option. Another good option, which is somewhat similar to military parole in place, in that it can help you get option even if you have an illegal entry. However, it does not help if you have something called a permanent bar, is something called Section 245I, adjustment of status. Now, this is something very important. If you have been in the US for the past 20, 30 years, and in the past, a family member, such as a brother or a sister, or a mother or a father, or even a spouse in the past, filed an application for you, or an employer filed an application for you way back when in the 1990s, before 2001, then you may qualify for Section 245I, adjustment of status. But just as with military parole in place, you have to make sure that you have your immigration history analyzed to make sure that you don't have the permanent bar. Another thing, now what happens if you're not married to a US citizen, you don't have any adult kids, or you have a problem called a permanent bar? Now, permanent bar is something that's a very, very serious immigration problem. It is the strictest immigration penalty that one can have, besides other penalties for offenses related to aggravated felonies. Now, the permanent bar is a bar to re-entering the U.S. that you trigger when you leave the U.S. Or after being here for more than 1 year, after 1996, I believe is the date, and you come back illegally, or you have been deported and then you come back illegally. This happens after 1996. Now, if you have the permanent bar, there are 3 main types of cases to try to fix and overcome the permanent bar so that you can get your green card. Now, the first way is through Vawa, which is what I mentioned before. Vawa is available to spouses of U.S. citizens or spouses of green card holders, or parents of adult U.S. citizen children, or children of U.S. citizens who have been subjected to extreme cruelty or physical battery. And some of these things, can, that's why I talked about in the beginning, like, how do you really feel? Like, what has your spouse said to you? But also the same goes to children. We have, certain children who may be giving their parents lots of problems and causing them some psychological harm or some emotional distress. And if this is the case, then VAWA may be an option. And if you have the permanent bar, the key is to show a connection between that harm and your entry or exit out of the U.S. that triggers the permanent bar. This is a little bit more difficult. So if that's an option, 2 more that I like are the U visa for persons who are victims of serious crimes. Now, the U visa is something that people ask about all the time. Does this, does my car getting robbed, count as a U visa crime? And usually, it has to be a typically felony nature type of crime that has caused some sort of psychological or physical harm. So if you qualify for a U visa and it gets approved, then you may be able to fix your status and ask for basically permission to basically get past the permanent bar. The next thing is a T visa. A T visa is something that is also not commonly looked at by everyone. And I want everyone to keep this in mind. A T visa can apply to anyone who has been in a work situation that has been really, really bad. And what I mean by that is this. If you have ever worked for somebody who has threatened you, you already know that you're being underpaid. You already know that you're being overworked because of your immigration status or your lack of your immigration status, lack of having papers, and your employer knows it. Has there ever been a situation where your employer has caused you to work more and then never paid you the time? Or they deliberately don't pay you, or if you ask them for proper pay or higher pay, your boss gets really angry. They yell at you, they threaten you, maybe you're afraid, you're made to feel afraid of having immigration called on you or getting arrested. Have you ever felt in your job that it is not just the typical not getting paid enough, but you feel fearful of your boss? If you feel fearful of your boss and of the consequences of going against your boss's directions, and you're an undocumented immigrant, then maybe you may have a case for something called the T visa. Now, T is for trafficking, and trafficking is something that is more than just not being paid the proper wages. Trafficking really occurs when you are fearful, you end up working because you feel like you have no choice. And not just the choice of not having a paycheck, but you don't have a choice in going against your employer's work. Now, trafficking can also occur in the domestic situation when your partner or your spouse forces you to do everything, and you don't get certain things unless maybe you don't get food, maybe you don't get to go out unless you do certain things. Keep these in mind. These are cases that are not always the easiest, but they are beautiful cases in terms of being able to help people get status when there may otherwise not have been hope. All right, so if you feel like any of these situations might apply to you, give us a call, 212-248-7907, which is something that I will explore in depth with every single person. And thank you for everyone who is commenting and questioning. I am live streaming on 4 different platforms, and I'm going to go ahead and answer as many questions as I can right now. Okay. Thank you. All right. I have a 10 years permanent resident card through marriage. Can I divorce my wife who is separated from Del Torres? Del Torres and anyone else who has a 10-year green card. If you have a 10-year green card and your marriage is not working out, what are the immigration consequences of getting divorced or getting separated? Now, if you get divorced immediately after getting your 10-year green card, then that may pose a question and a problem for you for your next stage of citizenship. And the immigration officer has every right to look into that to find out why you got divorced so fast. But if you've had your 10-year green card for several years and you are now separated or about to get divorced, there will probably not be any consequences to you. However, the burden of proof is always on you, even after you get your 10-year green card, to make sure you show that your marriage was always legitimate. What happens if you entered in 1994 but never been out again? From Pitt 31. 969. Pitt, if you entered in 1994, you never left, then you probably don't have the permanent bar. So give us a call and we'll explore your options. All right. Let's see what questions I have on Instagram. Hi, Nastasia. And Jose, I just saw you a second ago. My I-751 is denied to lack of evidence, and now I'm having a divorce with my wife from Rohan. Rohan, I'm sorry to hear your I-751 got denied. However, you have the option to refile your case. And especially it is important for you to do this right now, even if you get a notice to appear in court. Even if you get a notice to appear in court, you have to refile your I-751, and probably you need to do it with some sort of a waiver at this point, especially if you're getting divorced. I would love to help you explore to see if you qualify for an extreme cruelty and battery waiver, or if it's more appropriate to do a waiver for divorce, okay? Give us a call, 212-248-7907. My husband has a misdemeanor in his record with a fix. I'm a U.S. citizen, from Liz. Liz, it depends on the misdemeanor. And anyone who has any sort of criminal history, when you are asking for a green card, that criminal history has to be disclosed, even if that criminal activity has been, or that conviction has been expunged or dismissed or sealed. You still have the obligation to show this and to show what happened. And yes, it may affect your case, it may not. It really depends on what happened. Please give us a call. If any sort of criminal history, don't go through the immigration process alone. You definitely need to have an attorney by your side, because it will always be an issue, especially depending on how you present it and how you talk about it, okay? 212-248-7907. All right. Let's see. My husband and I got married virtually without meeting in person yet. He's been a felon, but this will get done next March. Does this mean he can't start filing for me to join my husband? From Natasha. Natasha, if your husband has a felony, okay, I want everyone to hear this. If you're getting married to a U.S. citizen, it is actually important to know what their criminal history may have been, because they may have certain criminal convictions that may actually prevent them from filing for you. But what happens? What happens if your spouse has criminal history that they never told you about, and all of a sudden you're finding out about it only after you get married, or after you feel like you have no choice to get married? Well, if this is happening to you, then you may have other things going on in your relationship that may qualify you to file for a self-petition. And, definitely you need to be aware of this. If your spouse is hiding their past from you, whether it is their criminal past, whether it is their history of debt, whether it is anything else, whether it is their prior marriages, guys, I've had people who I'm doing cases for who are married to people who are married like 3-4 times before, and they never told the immigrant spouse. These are bad signs to me. These are bad signs to me that your spouse is trying to control you, that your spouse is trying to force you into a marriage without your proper consent, really, right? Because when you enter into a holy matrimony, you need to know everything about your spouse. And these are the important things that may influence whether you want to get married or not, or whether you should get married. So definitely be on the lookout for that. Now, if you are legally married in the country that you have gotten married in, or in the state that you've gotten married in, you may not need to meet. I don't know. It really depends on the rules, Natasha. It depends on the rules of the country and of the state. Normally, to get married, it needs to be done in person, and depending on the rules. Okay, Natasha? I entered illegally. I need to leave the U.S. after marrying a U.S. citizen spouse. If long, how long to wait and come back legal in U.S. from Ben. Ben, so I think what you're saying is that you're married to a U.S. citizen, but you entered illegally, and you need to leave the U.S. If you need to leave the U.S. now, then you're probably going to trigger something called the 10-year bar to reentry. And if you need to leave right now, if you have no choice, then you can file for this waiver while you're outside the U.S. Typically, when you have to do this waiver, it is called the I-601 waiver. And for you to come back to the U.S., you would need to do the waiver while you're outside. Typically, I would say total amount of about 3 to 4 years to come back to the U.S. If you need assistance with this, give us a call, 212-248-7907. Hi, Gabby. How are you? Which course is good for New York Bar? Barbary or Themis. Themis I've never heard of, from Chetan. I did Barbary when I was studying for the bar exam. Why is USCIS issuing 24 months after expiration of the I-751 from Lori? Okay, ZZ. All right, so anyone who has a I-751 application in process, this is an I-751 to remove the 2-year condition on your 10-year green card. When you've gotten your green card through marriage, immigration is now automatically issuing a 2-year extension of your card. Normally, in the past, it was like 12 months, then they increased it to 18 months, and now it's 24 months. Lord knows what it'll be in the future. However, the reason why they keep extending this extension is because they're taking a very long time to process these applications. And in order to avoid the need for people to get InfoPass stamps or to have other problems, that's why they're issuing this, or they're increasing this. Oh, Liz, I see the second part of your question, that your husband has a misdemeanor. He was a teenager. Will he be able to fix? It may not be a problem, but it still depends. Normally, when you have a youthful conviction, it does not have the same sort of immigration impact that a conviction as an adult does. So yeah, it may not be a problem. Still need to get all the records to show what happened. Okay, Liz, give us a call, 212-248-7907. My husband has been renewing his work permit since 2011. Will it be easier to get his green card? From Jesse J. Jesse J. and anyone else whose spouse is only with a work permit, it really depends on, whether they're eligible to get a green card, whether, what problems they have, and will it be easier? It may be easier, maybe not, but it's always worth exploring the options. So give us a call, Jesse, 212-248-7907. All right. Oxigeno, Real. Buenos días, buenas tardes. When your case moves from NBC to the U.S. Embassy, how long does it take to get to the consular interview? From O'Neill. O'Neill, when your case goes from NBC to the U.S. Embassy, how long it takes in order to get that interview will really depend on that consulate. Please keep in mind that the U.S. consulates all over the world are still not operating at the regular capacity that they used to. So in the past, when NBC is finished reviewing your case and they transfer to the consulate to let them know that you're ready for an interview, in the past, it would maybe take 1 to 2 months to get an interview. Nowadays, we're seeing wait times of maybe 5 months or more. Mahmoud Khan is asking, what is my legal fee for Vawa cases? Mahmoud, that is something that I would love to discuss with you after going through your case to see what your case needs, what your case involves, and to see how much work we have to do. So definitely the fee varies depending on exactly what we have to do. the best thing I can say is give us a call. You have to have an appointment. I have to go over your case and do a consultation with you. 212-248-7907. My consultation fee is $150. Carlos is saying, just want to thank you for all your vids. Carlos, muchas gracias. Thank you so much. I really love putting out as many videos as I can and talking about immigration. That's why I do what I do, guys. I feel so very lucky to be an immigration lawyer. It feels like divine, intervention that I am an immigration lawyer, and that we're able to help people the way that we do. Is there any way that an F1 student can obtain a green card without marriage? Moumita, it definitely depends. And anyone else, I'm sure I've got lots of students watching. Now, if you're a student and you're on an F1 and you want to get a green card, traditionally you've got to go through it through employment. So if you have an employer who's willing to sponsor you for the right visa and you have the qualifications and you have enough time on student status to do it, then you may be able to do a green card. Typically, it's very hard for students to go directly from an F1 to a green card. Normally, you need to have a filler visa in between of either an H-1B, an O-1, anything like that. I don't really do these applications anymore, but certainly I can always refer you to someone. I got my marriage interview on August 16th, and until today, my status never changed, and I do not hear back from USCIS from Aileen. And I had another question here on TikTok about how long do I have to wait after I have my interview to get my results for the green card? And this, my friends, is the question of the day for every single day, for every single immigrant who is going through the immigration process with USCIS. It really depends. It depends on what issues you had. Are they planning on giving you a second interview for fraud? Or is the officer even in? What sort of reviews your case needs by senior officers? Typically, if you have not had an interview decision within 120 days after your interview, then you can make a service request and start making some noise on your case about what's happening. All right. Vikram Nanjiani is saying, my spouse left me after 4 months of conditional green card and I feel conned. Any options to deport her? Can she still ROC from Vikram? All right. I got this question a few times, and maybe you're not going to like what I have to say, but if you want to deport your spouse, if your spouse left you, I believe that marriages do take two to tango, right? It takes two to tango. And, I don't know what happened. I'm sorry you feel conned, but to say that you want to deport your spouse is a serious thing to me. But no, you cannot deport your spouse. Nobody can deport anyone except for an immigration judge or ICE, all right? These are the only people who can deport. And the thing is that if you want to say that your spouse has committed immigration fraud, well, it takes two people to do immigration fraud. So just because one person changes their mind about being married to you does not make it fraud. That's the thing. And I'm sorry that anyone has to go through this. Everyone deserves love and respect, whether you're a U.S. citizen or an immigrant. But please be careful about saying that you want to deport your spouse just because they left you. If somebody lived 10 years in the USA, can they get a green card from Ajay? Ajay, and this is something that I hear from a lot of people. Can I get a green card based on the 10-year rule? Guys, there is not actually anything called the 10-year rule. The 10-year rule really applies to persons who are in deportation proceedings. If you are in deportation proceedings, you have been in the U.S. for 10 years or more, and you have a U.S. citizen child, spouse, or parent who would suffer exceptional and unusual hardship if you were deported, then you can ask for something called cancellation of removal. But you cannot ask for cancellation of removal unless you are actually in front of a judge in an active deportation proceeding, okay? But if you are in deportation and you want to ask for cancellation of removal, definitely it is a good option to explore, okay? All right, everyone, I hope everyone has a wonderful day. I'm sorry I could not answer every single person's questions, but thank you so much for joining. I will be back on again tomorrow, so please keep watch, and I'll see you there. Take care.